Thank you very much, Professor Lim. Actually, I think most of us in this room probably do not agree that Professor Lim can only talk about small things. After all, Article 25 and the general comment is not a small thing. And many of us are actually deeply committed to seeing that right implemented fully in Hong Kong, and feel very passionately about it. And I think one of those persons who feels very passionately about it is about to speak to you now, and that's Margaret Ng.
Thank you, Gladys, and I want particularly to thank my preceding speakers on very inspiring speeches, on the basis that I have immediately changed my whole plan for my speech. In fact, what I'm going to do, with the permission of Madam Chairman, is to just provide footnotes to the speeches of the previous two speakers, particularly the first speaker. I'd like to first respond to the concept of convergence. Now, Professor Ramcharan said that he would like to see that perhaps done in a more tactful way in persuasion and in diplomacy. Funnily enough, that in fact was much more effectively done in an adversarial way in litigation. Now, Madam Chairman will not permit me to blow my own trumpet, but I intend to blow the trumpet of my learned leader. You might have noticed in the reports in the last 2 days on the Court of Final Appeals decision in a case concerning a police officer. His name is Lam Siu Po. Effectively, what happened in that case was that he was charged with disciplinary charges, namely indebtedness, and under existing regulations, he is not allowed to have any legal representative. And so, although he asked for a lawyer to represent him, he was told that this could not be permitted. And he went through the hearing. He was found guilty of the charge, and he was made to retire compulsorily, and his pension was to be withheld from him until the normal retirement age. So effectively, he lost his job, and he had no reach to his pension. He applied for judicial review. He lost the first hearing, represented by me. And he went on appeal. I represented him again, and we lost again. And so it is not blowing my trumpet. Before the Court of Appeal, we were very fortunate to have, as my leader, Professor Johannes Chan, who is, as you know, the Dean of the Law Faculty here. So that was, again, a cooperation. Now, what won us the case was precisely this, that what we supplied was Johannes supplied a very thorough analysis of where the international human rights law has moved on the question of fair trial. In fact, so a great deal, I really recommend this judgment, particularly the judgment of Judge Ribeiro, who went into quite a lot of details about the state of human rights law. As you know, there are two parallel developments. The development under the Human Rights Committee and all these general comments relating to fair trial, Article 14, paragraph 1, and the development in Strasbourg, the European Convention on Human Rights under Article 6. Now, the two are parallel, but they are not in step with each other, so that the superficial view of it, given the date of publication and so on, is that Strasbourg seemed to have moved forward, while Human Rights Committee's general comments were still lagging behind. Neither of them had a very, very clear principle of about the question of whether the protection of Article 14 1 or Article 6 of the European Convention apply to disciplinary hearings of police officers and the army and so on. And so, in the course of arguments before the Court of Final Appeal, the government's counsel suggested that because there is no clear, first of all, there is no complete agreement between the Human Rights Committee and the Court of Strasbourg, so that it's no clear principle had emerged. Therefore, they recommended that the court will not try to follow either of them because there is no clear principle, but to look at it on a case-by-case basis, and that for all the domestic reasons, police disciplinary tribunals should not allow legal representation, and that rule should be allowed to stay. Now, an intervention from Lord Woolf was this. He says, do you not think that we should follow whichever path which will bring us closer to the concept of a fair trial? And I think that is a blindingly clear question. And that is when we look at the domestic situation and when we look at the divergent views of what international law should represent or not, we should look for the principles which will bring us greater fairness. And if that applied to fair trial, that also applied to the right to vote and the right to be represented. Now, I particularly bring up this case because it is here in the rational environment of the courtroom, carefully prepared and rationally argued reasons, that we can see how the path of convergence should be mapped out. It is not, negotiation is difficult when David is talking to Goliath. But when you go to a law court, when each side is putting forward reasons, then we are equals. Not only because we are equal before the law, but reason is equal for everybody. The person who is more powerful does not have, his reason does not speak louder than someone who is less powerful. We look at the reasoning. So I hope very much that that has given us the kind of model that we should follow. It also is encouraging in that sometimes when you fight in the political arena for human rights, you feel that you are outweighed by so many different considerations. But there are also some of us who can go to court, who can argue on the basis of reason and principle. And so we all have a role in that business of convergence. And I hope that we will see more of that convergence. And I am consoled by one thought, and that is sometimes, even though Beijing does all sorts of things, it cannot and it has never ignored arguments in law before a law court. It may want to put it to one side for political reasons, but it will never say that that can be ignored. So this is where lawyers can do a lot of work. And I very much recommend it. It's a very satisfactory kind of work, although sometimes it can be very difficult. So this is the first footnote I offer. The second footnote I offer is when I heard Professor Ramcharan refer to the universal quest for freedom and rights.